Hello and welcome, everyone. I am Deborah Hadi, Senior Associate at Aman & Partners, and your today's session on the role of legal professionals in the capital market. I would like to thank everybody who has joined in the session today and our distinguished speakers, Yodit Kasa, Chief Business Development at Ethiopian Stock Exchange, Dr. Siyum Johannes, Consultant at Aman & Partners, Richard Harney, Senior Partner at Bowman's Kenya, and Dr. Talahun Kasahun, CEO of Ethiopian Stock Exchange, for taking the time today to share with us their expertise. To start off the conversation, I will hand it off to Dr. Talahun to give the opening remark on today's session.
Thanks, Deborah, and again, thank you, Aman & Partners team and Bowman's team. It's a pleasure. Again, I think this is probably a second legal professional specific webinar that we're doing. As an exchange, we take the legal professional as a key stakeholder. And of course, on a light note, we want the legal issues around capital markets to be very simple and to make them very cheap so that issuers and investors do not have to pay a lot of money to get the knowledge that they need. And I'm glad our partners at Aman and Partners and Bowman's agreed to this endeavor. But I think it goes a bit more deeper than that. As a young market, we have a role and responsibility to somehow, clarify outstanding issues and concerns that professionals in the field may have, and only on that basis they can create confidence and comfort for issuers and investors in the market. And I think our goal today is to perhaps make the conversation both sides, receive questions, but also share our thought processes. And we cannot think of a better team than Bowman's in terms of also sharing the experience of other jurisdictions. I'm glad, Richard, you were able to join us. And I think, Dr. Siyum, as one of the authors and perhaps a key player in the revision of our commercial code, he carries a lot of memory and knowledge in the field of commercial law in Ethiopia. So I am confident, the conversation will go beyond the capital market specific legislative regime and into a bit of more the commercial law as well as needed. And I'm very glad we're joined by so many attendees, and thank you for giving us your time today. And I wish us a very successful webinar. Thank you, Deborah.
Thank you, Dr. Talahun. So I will let our speakers to introduce themselves and share with us their expertise in the capital market area. Richard, we can start with you.
Thank you very much. Thank you very much indeed, and pleasure to be here. Good morning, everybody. Yes, my name's Richard Harney. I am a Kenyan and Irish and British, so a quite mixed legacy. I've worked in Kenya now for 32 years, but before I moved to Kenya, I worked in London, in the city of London, where I was fortunate enough to have, in the early part of my career, exposure to capital markets work in London, and a little bit also in Eastern Europe after the fall of the Berlin Wall and liberalization in Eastern Europe. But in Kenya, for the last 30 odd years, as I said, I've been doing a lot of M&A and corporate work with our firm Bowman's, and including in that a lot of capital markets transactions. So some IPOs, lots of secondary market transactions, takeovers of listed companies, bond issues, and so on. So I'm happy to be here, and I hope that you find my contribution to be useful. Thank you very much.
Thank you, Richard. Dr. Siyum.
Okay, thank you for the opportunity. I was as a partner in Get's Law Office working on lots of issues having to deal with companies. But of course, for the most part of my career, I was an academic staff at Addis Ababa University, mostly teaching business law courses, including company law. I was also fortunate enough to have had the opportunity to be part of the team that was revising the commercial code of Ethiopia. So I had the opportunity to witness some of the developments in the area of company law, and I have had the opportunity to also work with really good people and learn a lot in that process from them. I'm now consultant at Aman and Partners, and we have a team that deals with capital markets issues, and I'm a member of that team. That's all.
Thank you, Dr. Yodit.
Thank you, Deborah, and morning, everyone. As introduced, I'm Yodit Kasa. I'm the Chief Business Development Officer for the Exchange, former academician as well, like Dr. Siyu. But I'm feeling like I'm the only non-lawyer in this area, so I'll put that on the table. My background is finance. Been with Addis Ababa University for 5 or 6 years as a lecturer, then moved to the Association of Chartered Certified Accountants as an education manager, and then the country director. So if I've met any lawyers, I'm sure it's through that role, but happy to be here and learn, not only share from you all. Thank you, Deborah. Back to you.
Thank you, Yodit. So to all our participants, just in terms of housekeeping, as we start the conversation, if you happen to have any questions to our speakers, please feel free to write it in the Q&A chat. And also you can assign it to, if you want your question to be specifically to a particular speaker, please also mention that in the Q&A. So to start our conversation, I will start with, Yodit. There is currently, a statutory requirement to register existing and newly issued shares, which, goes on to filing prospectus, and it has its own process. So does the step of listing. So would you share with us what are the broad requirements of getting that registration and listing and the process involved that gives the investors, opportunity to do an informed decision as they invest in the capital market and companies listed in the capital market? So I'll hand it over to you, Yodit.
Thanks, Deborah. You kind of packed a lot of points, a lot of high-level areas. So I want to just break them down into a few core discussion areas that would help us in actually, having a conversation as well. So you've talked about registration and you've talked about listing. So that's quite right. Where we have to start, I have to say, is who's expected, right? Who's expected to register, first of all? Who are we talking about when we say registration is required? Obviously, the capital market proclamation, as well as the subsequent public offer directive, outlines who's expected to actually register the mandatory registration with the Ethiopian Capital Market Authority. Obviously, whenever we talk about registration and listing, people kind of mix it and also think it's complicated. It's not. I just want to put it out there. But obviously, who you register to is mandatory. It's with the Ethiopian Capital Market Authority. But the listing part, obviously, which is an option and a choice, is with us, with the Ethiopian Securities Exchange. So I think few kind of outlines is that when we talk about public offer, obviously publicly held companies, the proclamation as well as the public offer directive says, clearly says that when we're talking about registration, it's about companies who have more than 50 shareholders and a capital of 100 million that are expected to be registered or that are expected to register with the Ethiopian Capital Market Authority. So anything below that, whether it's through private placement or others, you can issue capital, but it's not required. It's not mandatory for this type of securities to be registered, which brings us to the more easy question, but more commonly misunderstood question of what is being registered when you talk about, public offer. It says it's not only commonly, we talk about in Ethiopia, a lot of us know shares and stocks. So we talk about shares and stocks, but when we're talking about registration, when we're talking about public offer, we're talking about all securities, including debt securities. It's not only stocks that have to be registered. I just want to put it out there. So if you're a share company, you have had, obviously we don't have that experience, but if you've issued debt instruments, and if you are above 100 million, if you have raised above 100 million ETB, Ethiopian birr, and have more than 50 shareholders, you're expected to register. So just kind of wanted to put it out there. Now that we've got the who, it's where, right? Where do you actually register? It's with the Ethiopia Capital Market Authority, and there are specific requirements and specifically how you're supposed to register and the parties involved, right? So if the company or the publicly held company that we just talked about has offered securities or is intending to offer securities, they would have to register, but the first thing you have to do is appoint a transaction advisor. These transaction advisors have to be licensed by the Ethiopian Capital Market Authority, and they would be the one that would be overseeing, or if you like, leading the capital raising process or the registration process as it is being said in this time. But there are also additional 2 service providers who are not obviously licensed by the Ethiopian Capital Market Authority that are also involved in this process. One is the independent legal advisors. That's yourself and everyone else except me, I'm assuming, as an accountant. It's the independent legal advisor who would be giving that independent legal view on the prospectus, on the documents that would be provided for the registration. In addition to that, obviously there would be an auditor, an external auditor, who would be reviewing the historical financial statements and giving assurance. So these are the 3 core service providers that would be needed for you to actually register your statements or file your registration statement with the Ethiopian Capital Market Authority. So what does it require? What is needed? Obviously, these are the 3 service providers that would be doing what they have to file and to fulfill the requirements, obviously, with the issuer as well. So in terms of and I would come back, when I've said 100 million, but obviously small offering is up to 10 mil as well. I just want to make that correction as well there. So in terms of the requirement, there are a few things I think I just want to highlight, if that's okay. The prospectus is the key document that would be required for filing, one. Obviously, the audited financial statements are the second document that would be required. You would have other, we call them, other corporate documents. It could be your license, your company tax identification number, identification certificate, other listed documents. If you go to the public offer directive, you would be able to see the detailed documents that would be required for you to register. So that's part of the registration requirement with the authority. Once that document obviously has been reviewed by the Capital Markets Authority and they've gone to the due process, there would be next step. If you're raising capital, there would be an allotment process. If that's not if that's not the case and you're simply registering, once they have done, we kind of miss one kind of directive through this process, which is the dematerialization process as well. So the securities then have to be moved from physical certificate, if you're just simply registering and not raising additional capital, to an electronic form and filed with the Central Securities Depository. So that's the next process in the registration, if you might say. And that's being done by the Central Securities Depository, which is housed under the National Bank of Ethiopia. Now comes the listing conversation, right? While we're going through the process. Obviously, I think people have been asking, and I just want to put it out there. It's not mandatory for a company to list, right? It's an option, but it's a value proposition as well. if you look at our listing requirement and also our requirement for over-the-counter registration, because if you look at the public offer directive, it's clearly outlines that a security, okay, once has gone through the registration process, can only trade in an exchange as a listed security or on the registered OTC, which is currently now obviously with the Ethiopian Securities Exchange. So you'd come to us. What we've tried to do, and I want to emphasize that on a simple term, is we didn't want to increase the cost of compliance. We didn't want to increase, as Dr. Delahon has initially highlighted in his opening remarks, we didn't want to increase the burden. It's more about making sure that we have the right type of companies that are coming and trading on the listing, as a listed securities or on the OTC as well. So we just have you would have to, when you look at our rule book, you would see that most of the requirements that are required that I have just mentioned for the registration are more or less what we're looking for as a documentation for the Ethiopian Securities Exchange for the listing process as well. But obviously, since we said we're going to outweigh, normally if you don't fit or if you don't meet the listing requirements, you would be trading on the OTC. That's how we see it. Although it's a choice, the choice is so minimal, it's not difficult. It's only a matter of if you decide. And if you don't meet the listing requirement, you'd be trading on the OTC or on over-the-counter market. So what are the listing requirements for securities? And I just would briefly touch on a few of them, and I'm managing my time, so you'd stop me, Devorah, if I overrun as well. But in listing, we have two kind of market segments for the equity. We have the main market and the growth market. In both of these markets, like I said, don't worry about the documentation. Whatever you've used for the registration process are the documents that you would be submitting to the Ethiopian Securities Exchange. So it's the same document, unless there are few things that we would be asking in terms of clarity from the listing team. So in terms of the requirements specifically for listing, we're looking at the operating track record of the company. If you'd like to say around 5 basic things are what would be differentiating you if you're going to the main market or the growth market. The operating track record of the company, the profitability of the company, the financial statements, the market capitalization, and the requirement of public float or free float, as we call it. So if you're looking at going to the main market, in terms of operating track record, we're looking at 3 years operating track record. In terms of profitability, we will be looking at profit after tax, at least one of the last 3 years. It's not all 3 years, one of the last 3 years. You have to have a profit. You have to have been a profitable company. The financial statements, we would be looking at 3 years audited financial statements that are prepared in international financial reporting standards or as are applicable Ethiopian accounting standards. In terms of market cap, if you're going to be listed on the main market, we're looking at a minimum total market capitalization of ETB 500 million, above ETB 500 million. If your company is, in terms of public free float, if the company is has a market cap of 500 million up to 2 billion, you would be required to have a 15% free float. But if it is above 2 billion, you would be required a minimum of 10% free float. So that's the requirement. When we're talking about free float, and I'll come to that if it's needed for clarity, we're talking about securities that are not held by promoters, securities that are not held by executive team. So that can easily, freely be transferred. That's what we're generally looking at when we're talking about free float. In terms of the growth market, and I'll stop here, Deborah, you would stop me if I overrun as well. In terms of the growth market, the same requirements, but a bit lower. So let me start with the public float. We're talking about 10% again, but this has to be held between, by 50, minimum 50 people. 50 shareholders. So that's where, if you look at, that's why we've aligned it. If you look at the 50 shareholder requirement for registration, this is where the minimum requirement for 50 is coming as well. in terms of the market capitalization, from 50 million up to 500 million. In terms of financial statements, we're looking at 2 years financial statement. In terms of profitability, here we're looking at growth prospect. It's not about profit, but if your revenue is actually growing at least by 20% every year for the last 2 years, that's what we're looking at in terms of growth prospect for the growth market. So it's not profitability per se, but it's more or less a proxy, if you have to say. And then in terms of operating track record, we're looking at 2 years. So these are the main requirements, and I would obviously put some documents on the chat if need be for people to look at and ask questions if they want to, Deborah. But I can pause here. And then obviously the OTC market is the same documentation, same requirement, but the difference lies in not even ongoing disclosure. It's basically, like I said, if you haven't met the listing requirement, and if you don't want to see your price being discovered, then you would be falling on the OTC market. So that's the general requirement. It's not a specific difference between how we would be looking at them. I would pause here,
Thank you.
Deborah.
Yeah.
Thanks.
Thank you for sharing that with us. I'm sure we will have follow-up questions on that, and I am receiving a few questions on the chat, so we will come back on the requirements. But as you mentioned, legal professionals are one of the key service providers that are not licensed by the Ethiopian Capital Markets Authority, but play a key role in the capital market ecosystem. So on that, I will move on to Dr. Siyu to share with us what is the expected role of legal professionals in the Ethiopian capital market. And then also, Richard, if you would also add your thoughts on, in terms of the practice in international and regional markets, what is the role of lawyers in the market, as well as the interaction with the other service providers of the market. So I will hand it over to you, Dr. Siyu.
Thank you, Deborah. I would like to state from the outset that we want this interaction to be more of interactive rather than this presentation, more interactive rather than a monologue. So Richard, please feel free to intervene whenever you think you have something to contribute. If you raise your hand, I will stop and of course then proceed after you make your contribution or after you state your views. So when one reads the capital market laws of Ethiopia, one gets the impression that actually lawyers do not really have much role in this process. That was my impression when I first read the laws, particularly the Capital Market Service Providers Directive. But when one looks a little deeper, one discovers that there are so many things that lawyers can do for the proper functioning of a capital market. Particularly if we see the crux of the gist of capital markets laws, the purpose is essentially two. They have two major purposes. One is to give investors and creditors all the information that they need to make, a considered, informed decision as to whether to buy, for example, shares in a company or whether to lend money to a company in exchange for debt securities. That means they need to have all the information that a reasonable investor would need to make a decision before investing in a company. And what kind of information would a reasonable an investor want before investing in a company? Several things would be necessary to make an informed decision. For example, does the company have the proper licenses to engage in a particular sector? This is one thing that the investor would want to know before investing. Another question, for example, is does the company have any problems in terms of, let's say, does it have proper patents or copyrights, or depending on the sector in which the company is active, intellectual property, title to intellectual property. Does it have title to the property, even corporeal, incorporeal property that it thinks it has? All these things the investor will want to know. Again, the investor will want to know, is this company involved in major litigation? If there is an ongoing litigation, is there the likelihood that the outcome would be against the company, for example? The investor would want to know, again, things like whether the company has a dispute with employees, whether the company's collective agreement with the employees is such that it poses potential problems for the success of the company. So also, the investor would want to know about major contracts to which this company is a party. How are these major contracts structured? Is there a risk of a major default on the part of a contracting party which has a contractual relationship with this company? So all these things must be closely scrutinized, analyzed, and weighed for the investors to have actually the necessary information to make an informed decision. And who is best placed than lawyers to do these things? Who is best placed to gauge whether a case, an ongoing case, will go against the company or not? Who is best placed to assess whether the major contracts to which a company is party are likely to cause serious problems for the company? Lawyers are best placed in these regards. So lawyers have a very, very critical role in assessing the worth of a company, especially when it comes from the perspective of legal issues and the risks some legal issues pose to the company. These things have not been clearly stated in this capital markets laws of Ethiopia, but they are critical. Anyway, if we were to talk about the role of lawyers in terms of the different phases of going public, we could talk about preparatory stage, we could talk about the listing, registration of securities and going public, and also listing stage. And we could also talk about the role of lawyers after even listing and registration of securities, because of the ongoing disclosure obligations that companies have. So I would say at the preparatory stage, a company that wants to go public, that wants to have or required to have, as the case may be, to register its securities and to engage in public offering, must at the preparatory stage engage the service of lawyers. Why? Because if it discovers by self-assessment, that it has major problems in terms of title to property, in terms of pending case risks posed by pending cases, or not having secure, let's say, licenses, etc., it can fix those things ahead of these things being discovered by others and dampening the price of the shares, or the appetite of people who, as the case may be, would be lending money in exchange for their securities. So at the preparatory stage, I would say a company is well advised to initially engage lawyers and seek service to do an in-depth vendor due diligence, if I may say. So this is one thing at the preparatory stage. Of course, going beyond this, lawyers may contribute in various ways at the preparatory stage. For example, one way is to strengthen the company's corporate structures and policies. Before going public, the company may want to revisit its structure. How is my company organized? Do we meet, for example, the requirements of company law of Ethiopia? Do we meet the requirements in terms of corporate governance? Let's say if it is a bank that's going public, do we meet the requirements in terms of corporate governance that the National Bank of Ethiopia expects from us? These things have to be revisited, and if there are problems, these things must be fixed ahead of going public. Another thing is Also to have their own internal structures that enable the company's success in the capital market. Let's say the company may want to set up internal mechanisms for ensuring that the company will be able to meet requirements as on ongoing basis when it participates in the capital market. Richard has raised his hand, so I would like to give him the opportunity.
I think you're being very clear and very clear. I just want to add to what you're saying there in relation to the role of lawyers. A few capital market transactions I've seen over the years, and fortunately very few, which have gone wrong for one reason or another, tend to not necessarily be full listings on the stock exchange, maybe OTC markets, private placements, and so forth. Tend to be where the lawyers have not had a proper role, and the sponsors or the company have not really engaged lawyers to work really thoroughly on preparing the company for the public offering. The other thing is, and lawyers' critical role is preparing the sponsor, that is maybe the current owners of the company, shareholders, if it's a family business, family members, especially the board of directors or management of the company. That the lawyer's responsibility is really to make sure that all the information that's been given to the market is clear, unambiguous, and not misleading. And that process of explaining to the client, whoever it may be, whether it's the company, as I say, or the directors or founders, to be clear on what their responsibilities under the law are. And I'm sure, and Professor will be very clear on this, I'm quite sure that the Ethiopian Commercial Code contains quite strong provisions dealing with responsibility and potential liability of people who make misleading statements, don't provide sufficient information, and so forth. So, we have a critical role in making sure that the company and the people behind the company are ready to face the public and take responsibility. So let me just add that for the moment, and please back to you, Professor. Thank you.
Thank you. Actually, just to add a small point to what Richard raised, the Capital Markets Authority, the Capital Markets Proclamation has actually a certain section on liability for incomplete disclosure or false statements, and the penalties are actually very rigorous. In most cases, of course, depends from case to case, but from 7 years to 15 years of rigorous imprisonment for submitting false or wrong information, incomplete information. And in case of companies, the company's management, board of directors members are also subject to removal, loss of license, and imprisonment. So actually, the law is very rigorous in terms of sanctioning provision of false information or incomplete information in this regard. Anyway, just to raise two small points regarding the preparatory stage. Generally, lawyers could be helpful in walking the company's management through the rules, just enlightening as to what the rules are already, what to expect in the process, as Richard mentioned, and what the potential risks for the company and the management themselves is entailed in this process. Another is the company may adopt, various committees, code of conduct, insider trading policy, and all these things in preparation for going public, so that it makes the most out of this process. Another thing, of course, at the preparatory stages, as one would expect from the traditional role of lawyers. Lawyers could help a company that intends to go public to hire capital service providers. For example, structure a company's relationship with its investment bank, with its other, we have some 15 service providers that have been listed by the directive, and lawyers can assist the company, structure relationship with these role players in that, and the going public process and all this stuff. So this much about the preparatory stage. If maybe if you don't have if Richard has something more to talk about this, I would let him state something. Otherwise, I would proceed to the next stage.
No, I think, thank you. Just a couple of things. I mean, just to underscore what you're saying, that the amount of work that's needed to bring a company to the market, particularly with a listing on the stock exchange, is quite significant. And the board of directors, management may have made the decision, the shareholder may have made the decision to go for that process. But there's a lot of work involved, and that's where professional advisors come into the fore, whether it's a transaction advisor, and as in this case, lawyers. We take some of the load off the company itself in preparing it for listing, and with the experience that we bring from previous transactions involving listings and so on, we're able to work efficiently to make that happen, and not create too much of a burden on the company itself in preparing for the listing. And it's very important as well that the lawyers come on board early in the process rather than right at the end. In fact, in my experience, sometimes the lawyers can be the ones who initiate the process in consultation with a client who is ready to take their company public, and may then ask the law firm to assist with finding a transaction advisor who will help them with the process of application to the ESX and the listing process with the ECMA and so on. So I think it's not very much not a last minute process of bringing the lawyer in. We're there from the beginning, and I think we share a very important role with transaction advisors, and of course, as Professor mentioned, also with the company auditors in preparing the audited statement. So let me leave it at that for now, and back to you, Sam. Thank you.
Okay, thank you. Once the company has decided to go public, or is required to go public, as the case may be, there are certain roles which the capital market laws clearly indicate are to be played by lawyers, but there are also other things which are implied or are things that lawyers do as a result of their normal practice. And one thing is, as we know, the capital markets laws require when a company is registering its securities, or when it's doing its public offer, or when it's listing also, it always needs to provide a prospectus. And the prospectus is actually an instrument for divulging or disclosing all the information that people who invest in the company will need to make an informed decision, and creditors will need to make an informed decision before extending credit to the company. And so in the preparation of the prospectus, lawyers will play a role by showing what I stated earlier on, whether the company has ongoing disputes and the risks that those disputes pose, or the major contracts, etc. The capital markets laws actually list the things that are to be supplied as part of the prospectus, and major contracts, litigation, all these things have been listed. So in this regard, lawyers will provide input in the preparation of the prospectus. Of course, they will not be the only ones preparing the prospectus, but they will provide or supply critical contribution to the preparation of the prospectus. This is one thing. Another thing that comes along with prospectus is the company's memorandum of association has to be also presented. And in drafting this memorandum of association, or in assessing whether the memorandum of association meets the requirements of Ethiopian company law, or also in some cases like banks, the requirements of the National Bank of Ethiopia, laws or issued by directives issued by it, all these things have to be assessed, and the memorandum of association has to be prepared in line or in compliance with those things. So this is another role that they play. Another thing is actually the capital markets law, particularly the directive on public offering, has an interesting provision, Article 2, Sub 14, which says lawyers may actually be, in some circumstances, be appointed compliance advisors. And as compliance advisors, they are actually responsible for, coordinating the process, guiding and coordinating the process of going public. So they may become compliance advisors under certain circumstances. This is one role. Another role that lawyers may play in the capital markets is, as Yodit earlier on mentioned, they are external independent, they provide rather external independent legal opinion. And this is a role that they can play. Other roles include, of course, issuance of statement attesting compliance of the memorandum of association to commercial code requirements. Also, this has been explicitly stated in directive number 1030/2024. So they may have a role in this regard. And of course, responding to various issues in the process. I would say these are the major things that lawyers play, roles that lawyers play in the process of going public.
So if I could add to that from personal experience, and I'm not sure what percentage of those attending this webinar are lawyers themselves, but let me assume that quite a number of people on the webinar are lawyers. I think generally us lawyers tend to think that we're better at writing documentation than many other professionals, whether it's auditors, accountants, or even bankers. And so what I found over the years, even from my time in London, but especially here in Kenya, is that prospectus preparation. Yes, there are many legal components to the work that has been explained, but just actually drafting the document itself is often a responsibility that is shared, sometimes even taken over by the lawyers to the exclusion of others, but is usually shared, and lawyers have a very big role in making sure that not only all the disclosures and legal obligations in the document are met, but also that the document reads properly and is clear and so forth. After all, at the end of the day, the prospectus is really the shop window for investors. It is the opportunity for investors to look at the company and understand the company, understand its business. And on the other side, it is for the company to market and sell itself and to say good things about its business historically, good things about its current management, and indeed possibly even about its future prospects. So it's really important. It's a really important document, and lawyers, I think, actually have a bigger role in preparing and making sure that that is really, really top quality, along with other people. So that is something I just want to emphasize, and something we see a lot, and I'm sure you will probably find happens in Ethiopia as things develop. Thank you.
Okay. So to the third stage, post going public, post licensing, post actually also as the case may be listing is the obligation to provide ongoing information to the public. That is ongoing disclosure. Of course, the law is very detailed into as to what has to be provided on ongoing basis to the public or to the investment community. And of course, whenever something material happens, such that it would have impact on the value of the securities of a company, those things have to be disclosed. And lawyers will be involved in weighing what is what has happened. For example, is worth disclosing, or is it relevant or not? All these things they have to do. Also, there are many issues that happen, or many things that could happen after a company has gone public. There are issues of insider trading and all these things, and lawyers play a critical role in supporting the company comply with the requirements of the law once the company has gone public. But the details are essentially about many, but weighing what information to disclose in a timely manner, and what is not required to be disclosed, and of course making sure that the company has internal rules and protocols that make it possible for the company to comply to disclosure post-registration disclosure procedures. But that's it generally, in the interest of time, I think.
Thank you, Sigyu. We have a few questions that are posed to our speakers. Before we move on to that, Richard, is there anything you want to add on that conversation, or we can move to the questions?
I'm happy to move to the questions. I think there was, I think the idea was that I would just say make a few remarks about some of the experience here in Kenya, which I'm happy to do before we go to questions, because I know from experience questions can take some time, and rightly so, and that's a very good thing. But so maybe I'll just say a few things about Kenya, and I would expect that quite a lot of people who are on this call will be pretty familiar with the history of capital market transactions here in Kenya. But just let me give you an overview. I mean, our stock exchange was set up more than 70 years ago. So by global standards, we're middle-aged. By your standards, we're very old. I understand your market's very, very youthful, and very exciting time that Ethiopia is going through with this liberalization. But our market's been in existence for quite some decades, and it tends to go through phases of growth and excitement and development, and then goes through quieter periods. And I think, without getting into too much detail, I think sometimes that reflects whether it's political or economic factors, within the country. We have quite a sophisticated exchange, and I'm sure it's probably it's had to evolve and develop from an exchange that used to be pretty much run across a bar in early 50s when it was established. I think there was just a counter with a man standing behind it with a board and marking up prices and so forth, while brokers and traders would come in and have their lunch and so on. So it's now a very sophisticated market, and I know that you've been fortunate in Addis Ababa to be able to adopt the latest and best technology, latest and best systems. So there's no need for me to explain how that works in Kenya, because your systems are probably more advanced than ours are nowadays. But we have been through a significant period. I mean, the exchange was demutualized, and others. It used to be owned by the stockbroking companies. It was demutualized and is now a publicly traded company itself. That took place about 10 or 15 years ago. We've got 10 firms of stockbrokers. 17 investment banks locally licensed, 43 fund managers, in addition to share registrars, trustee service providers, and so forth. So it's a fairly complicated and comprehensive infrastructure that provides the market. The regulator is like you have in Ethiopia. We have a capital markets authority, Kenyan Capital Markets Authority, which is the ultimate or the pinnacle authority, and itself licenses the operations of the Nairobi Securities Exchange. We have a very robust and very comprehensive, some would sometimes say too lengthy, set of laws and regulations, covering all manner of transactions on the stock market. So obviously very comprehensive rules on IPOs and bond issues for disclosure, but also comprehensive rules on licensing of market intermediaries, comprehensive rules on secondary offerings, and very critically, as Professor was citing, very comprehensive rules on corporate governance, and on disclosure requirements post-listing, which are really important. And indeed, I think a lot of lawyers forget just what a critical role we do play, sitting with companies and advising them on what happens after they've gone public. I think it's, as I said earlier on, it's probably fair to say that the Kenyan stock market has had its ups and downs. Currently, the market capitalization is around about the $2 billion mark, around about. It's been in the last few years, it's been quite a lull of IPOs and equity transactions. The last serious IPO was really in 2008, which was the listing of Safaricom, which was a record transaction for our market. But that's a long time ago. Since then, there have been a couple of listings of smaller companies. But now, as of 2025, things are looking up, and there is significant new interest in our market. And there is one or two IPOs that are in the making. One of you may have read about the proposed Kenya Pipeline company, which is government owned, to be floated on the stock exchange. That's expected to raise around about 100 billion Kenyan shillings, which is quite a significant. That's about not sure what is it, $850 million for the government alone. So that will be a big transaction, and actually our firm is pitching to be appointed as legal advisor for that. The market is heavily concentrated, unfortunately, in Kenya. It's dominated really by very few stocks. Safaricom accounting for as much as 35% of our market capitalization. That's one single company, which is it's a wonderful company. It's very successful, but unfortunately, it doesn't tell a good story about the state of our market. The rest of the stocks are really divided between financial institutions, mainly banks, many local banks, and also some foreign-owned banks, and a few other significant counters like Kenya Generating Company for electricity supply, East African Breweries, and a few others. So unfortunately, the market, there are 60 odd companies, 65 companies listed, which I think by Ethiopian standards is very small, because from what I understand, the number of companies that will come through to the market in the next few months or the few years is going to be a lot more than that. And I think that the problem is that there just hasn't been enough interest in our market in recent years. Low liquidity, high compliance and transaction costs. So I think there are a lot of lessons that can be learned from Ethiopia from our experience in East Africa. As I say, we have a developed, sophisticated market which has not functioned as well as it should do, and certainly one of the great weaknesses I see certainly from my time in London is actually listed companies coming to the market for secondary offerings. So that is making rights issues or placing of shares to raise additional capital as equity investors, but also bond issues, and that's been something that's really short supply here. Probably 80-90% of our corporate finance transactions in Kenya, at least, are actually done by banks, and they're not done through the stock market at all. So there's an opportunity. I hope that the ESX and the Capital Markets Authority of Ethiopia will be managed to encourage the investment climate to see it become a real capital market. That's to say, where investors can invest in, top quality companies and get returns, but also top quality companies want to come to market, want to remain listed, and want to use them to raise capital, which is, after all, what the capital markets are all about. So that's probably enough for me. I think it's I'm happy to answer any questions, talk about some of the particular transactions I've worked on. Probably the most prominent one that I was involved in, but actually when I first came to Kenya, which shows you just how thin the amount of work has been, was on the flotation, on the privatization and then flotation of Kenya Airways on the Nairobi Stock Exchange. But that was back in 1996, a very long time ago, and Kenya Airways is still a listed company, but unfortunately has not been quite as successful over the last few years as people would have liked. But anyway, there's a lot to be learned from that particular company as well. But let me hand it back to you, Deborah, and thank you very much.
Thank you, Richard. So I think we can dive into our questions. We have plenty of questions to go through, and maybe on the first question, I will still come back to you, Richard. So one of the questions that we have is particularly for you, and I think our audience, Solomon, is asking, how is it like as a lawyer practicing in the capital market practice area, and do you feel that you miss not practicing the other sectors of law? So I think we'd just like to hear your experience on that, and I'll move on to the other questions.
Well, I mean, you're talking somebody, I'm preaching, converted. I'm already a committed capital markets lawyer. When I started working in London in a long time ago, I won't necessarily give you the date, but a long time ago, I was working with Clifford Chance, and I was given 2 books on my first week in the office. One was a thing called the Yellow Book, which and the other one was a Blue Book. And the Yellow Book was the London Stock Exchange listing and disclosure requirements manual, and the Blue Book was the London Stock Exchange panel on takeovers and mergers code of conduct. And basically those were the 2, along with the Companies Act, the UK Companies Act. Those were the sort of 2 Bibles that basically led me through the early part of my career. So I kind of started off, and I enjoy it. I think it's the reason I like it is it's transactional. It's very transactional. Seeing a company taking it from a privately owned, maybe a family business, maybe a successful company, seeing it go on the stock exchange, go public, investors participate. And there's an awful, as I said earlier, there's an awful lot of ongoing compliance and disclosure work in capital markets. But having said all of that, just to finish off trying to answer the question, I do a lot of other legal work as well, predominantly mergers and acquisitions, so what we call private M&A. So just buying, selling companies, businesses. I do a lot of work in finance, financial institutions. So I don't only do capital markets work. I mean, to be honest with you, if there was more of it here in Kenya, I'd be quite happy to spend all my time doing it. But one has to have a diverse range of skills.
Thank you for sharing your experience on that, Richard. Next question is for you, Dr. Sinu. Our audience has asked, on Directive 1030, there is no clear legal requirement that litigation cases should be reflected on lawyers', I believe, opinion. So, and also our audience has asked, the litigation status of companies is provided on their audit statement of the issuer. So do you still think, or why do you think that it's important, the litigation status is important to be included in the documents that are being drafted by lawyers of companies listing on the stock market?
Okay, good. As I said at the outset, actually, the very purpose of capital markets laws is providing investors and, of course, people who intend to extend credit to a company to make an informed decision about the risks of investing in that company. One of the risks, and this has been stated actually as a principle, that this has been stated in the capital markets laws of Ethiopia. Information that is required to make informed decision must be supplied to investors. And one of the cases, one of the issues that an investor would want to know is whether this company is subject to a major litigation, is involved in a major litigation, and the risks that this litigation poses to the company's success. So whether it's stated as probably it could be true that the audit statement has to state this, but who will assess the risk posed by a major litigation? The auditors will not be able to assess the risks. At least they will need the input of lawyers to assess the risks that a major litigation poses to a company. So I think that's why when I said at the beginning, when one reads the capital markets laws of Ethiopia, one gets the impression that they don't have really much role. But the role of lawyers is actually more than one expects when he just reads or skims through the capital markets laws of Ethiopia. I think this is very critical to investors, and the principle has been already embraced by the capital markets laws of Ethiopia.
Thank you, Sigim, on that. Another question is for Yodit. Two questions, actually. One comment is that, the process of hiring advisors, transaction advisors, be it for registration or listing, happens to be costly. And our audience has asked, do you not think that this has made the whole process, maybe particularly registration as its statutory requirement, to be burdensome on issuers? And there's also another question, if you can give some examples and elaborate a bit more on the concept of.
Thanks, Deborah. So let me take a stab at the first one, and then maybe Richard can help on the cost of compliance, because he also has flagged it. I think there are a few things I do want to put on the table. Obviously, there's always that initial cost, right? Initially, when you're coming to the market, this is a new market, and that cost would look very high. But then the question I always come back to asking is, when you're raising capital, right? Whether you're actually going to a bank and borrowing and you're actually paying, right, an interest on it, whether you're actually, going through a public offer and raising equity, there has to always be a cost to the capital you're raising, right? But if the cost doesn't make sense, meaning if the cost, right, is too high than the benefit of the capital that you're raising and actually investing, that would always push the market out, and we're cognizant of the fact as well. But what would be, we're new, right? It's a new market, it's a new setup. So although I still share some of the sentiments and some of the comments, right? through rigorous, because the transaction advisors, well, we expect some of you as lawyers would actually cut down on the cost, as Ilhana said. So some of the cost actually is coming from you, so you can actually look at that as well. But in the seriousness of the tone, there is always a cost of capital in terms of raising capital from the public, and that doesn't have to be undermined. It's about the benefit, and the cost has to make sense, right? If you're coming to a public market and actually paying all that, then the benefit that you're getting has to outweigh that for you to come to a public market and raise. And that's why you will see that many companies that actually come to a public market and raise are large companies, right? So that you're actually, very large companies have a very strong corporate governance, have strong audited financial statements. They're actually still able to cover some of the cost, but the benefit is not only for the company, but also for the people that would be investing in this company as well. So we have to actually look at it as from the investor side as well. So although there is always a trade-off, there is going to be a cost. We have to agree on that. The question is, what's too much, right? If I think it's Brahanu who has asked that question. So what is too much for who, right? Based on the value and the benefit and the cost, we really have to look at it. And the second element is always about cost, right? Competition. So if you have 1, 2, investment banks or few transaction advisors, the cost could be high. But when the market is growing and when the competition is high, and we're actually also understanding the process, the system, and we're picking on that, I would assume the cost would actually come down as well. So for me, I would put it in the table. It's not to say it's not costly. The question is, what is costly? It's about raising capital and actually giving the investor the right disclosure, the right information for them to come and invest in your company. And alternatively, right, you're coming to a public market to raise capital. So there has to be some kind of safeguard that has to be put in place for you as well as for the investor. So that's where the cost is actually being looked at. And obviously, like I said, it's a learning process. The third element is, so we will look at this and try to see how we would actually explore. So that's my personal comment and view if I have to, but I can let Richard add from the Kenyan experience as well. I don't know if you've seen our cost. We've looked at Kenya and other markets to really come up with both the listing, the registration fee. They're very comparative to that, including the trading fee, but happy to hear your view, Richard.
Yeah, it is a common theme around capital markets is the cost. I think as you did made clear, it's really a cost benefit analysis. You're not going to go public and invest the time and resources needed to go public unless you really think there's going to be a benefit to the company. I'm talking here about a listing on the ESX, and that's access to the public markets, to access to capital, and with it, reflection in the value of your business through the reflected share price of the trading on the stock exchange. If your company is doing well, then the value of your company will go up. So those are some of the benefits. The cost seems high, and it's not. I don't want to say it's a one-off cost. You only incur it once, but certainly the IPO stage of going public initially is more expensive because there's a lot of work, as we've explained in this call, from transaction advisors, auditors, and of course lawyers. So it is not going to be a cheap exercise. But once you've gone public, then depending on what you do with your listing going forward, you can look at it a bit of as a one-off expense, which of course can be expensed through the P&L of the company and so forth. So it's not cheap. What we found in Kenya is a bit of a two-tier structure on fees. Yes, there are the fees set by the regulator, whether it's approval fees from the ECMA or whether it is listing fees set by the ESX, which are probably percentages or statutes and are set by the rules, or fees payable to advisors like bankers and lawyers, which tend to be more negotiable. And when I say negotiable, what, as I say, two-tier, what we found is over the years there are there are some companies that will actually just look for the cheapest they can find and pay rock bottom low prices and put out the tender for the advisory work to a number of law firms in the case of what we're talking about here, and then they'll pick the lowest, the cheapest. I personally think that's not necessarily a very sensible, because you know, if you're not likely to get a lawyer or a law firm which has the right kind of experience or the right people with the right knowledge of this process. And so we do find people who are undercutting and very low price, but actually tends to be for the less reputable companies. The larger, more successful companies will be prepared to appoint a law firm. And when I say a law firm, I mean you can't do this job as a single practitioner. You know, there's quite a lot of different elements involved. There's quite a lot of work that goes into it over a period of time, maybe a few months of preparation. And if you're a court lawyer and you spend most of your time in the law courts, you're going to find it very difficult to also be advising companies that are looking to go public, because you're expected to be available for meetings and reviewing documents and so on. So we tend to work in teams. You know, on an IPO, we could have anything between, you know, two to even up to 15 to 20 lawyers working on such a major transaction. So those costs are bound to be higher. And I think what you'll find in Ethiopia is that the market will find a place for itself, and that's what an open market is all about. So over time, you will find that there is the kind of fees that are expected to be paid for this kind of operation for your professional advisors, but it's never going to be cheap. So that's what I would say. All right.
Richard, just before we move on to the question that was posed to you, just a follow-up here, Richard, for you. One of the questions that we have was, what's the role of in-house legal counsels that we should expect on the registration as well as the listing process of a company? And if you can share your experiences, and I don't know if Siyum also, you have something to say on this, you can add.
Yeah, it's a good point. Good question. To be honest with you, you know, not all companies will have in-house counsel, but where there is an in-house counsel, he or she will, I think, perform a very important role as a link between, a connection between management and the directors, the owners, and the external advisors, whether it's the bankers or the auditors, or in our case, the lawyers. So the interaction between in-house counsel and external law firms is very important. Quite often, the in-house counsel will be the individual who will have the relationship with a law firm and will want to develop that relationship by asking the law firm to get involved in helping with the listing. So it's not exclusively that the company's external lawyer is the one that does the listing, because there may become certain law firms and lawyers in Ethiopia who garner a reputation for, you know, having particular experience and skills in capital markets work. So it's really, the in-house counsel has a really important liaison role between the external and the management and the company itself. Very important.
If I may add,
just before you add on that, Siyum, I was hoping you could also touch upon a similar question that was asked on this, is if there is no, you know, when thinking of registering and listing on the stock market, as you rightfully mentioned, there are a lot of requirements that only a legal professional can handle. So is it possible to either interpret this, or are there any specific legislations that you can point us to that sort of make it a mandatory requirement for a company to have an in-house legal department if if they qualify as a public company and they have to register, or if they are thinking of listing.
Okay. One, to start with what Richard mentioned, in-house counsels can be a liaison or point of contact between the company and its lawyers, the company, and all the 15 or so role players that have been identified as service providers to in the context of capital markets laws. Also, I think in-house counsels can play a role in negotiating and drafting contracts between the company that's going public, for example, and the service providers. So I think they can structure this kind of contract with the service providers, as the case may be. But going beyond that, I think it's very difficult for in-house counsels to really assess the risks that the various things I was trying to mention pose to the company for a variety of reasons, but most importantly, because also there is a question of conflict of interest. For example, I said I was trying to say that one of the things that has to be assessed is what kind of risk does an ongoing litigation pose to the company. And in-house counsels may be directly or indirectly involved in the litigation itself. So for them, it's difficult to give an objective assessment because also they may be somehow implicated in the process, and they may be afraid of divulging or exposing what went wrong when the company concluded the contract, when the litigation started, all this stuff. So they may have a role, but I don't think they are in a position to really play essential role in terms of providing input for the prospectus and all these things. So this is one thing. Probably the question that Deborah raised, the other question, it was not really entirely clear to me, but I think it's the role of lawyers has not been clearly stated. Some of the roles are not clearly stated in the capital markets laws of Ethiopia. So how do we justify the kind of roles we're stating they play? One is some of the roles that lawyers play actually follow from their traditional law, traditional role. For example, assessment of the risk a litigation poses. Nobody can do it other than lawyers in terms of where the case will go. Assessment of risks that major contracts pose. Nobody is better placed to do to make such an assessment. So some of them are actually things that follow from the very function that lawyers play in interpreting laws, in structuring contracts, and in interpreting contracts and making assessment of what will happen if a case goes to a court, or cause a case which is in a court, which way a case which is already in a court will go. So I think that's it.
Thank you, Siyu. I'll come back to you, Yodit. There was another question about if you can elaborate a bit further on free float and maybe give examples before I move on to the other questions.
No worries. Thanks, Deborah. I think on the team of in-house lawyers, specifically because we've engaged with a lot of issuers and issuing companies, I think it's really worth highlighting two things. When a transaction advisor is onboarded to actually do the prospectus, which is the core document that would be required for registration, there would be a lot of, it's like, think about it this way, and I joke always about this. It's like hiring a consultant. The consultant would not be getting the documents, would write and structure and shape the document for you, but obviously it's the core internal team that would be providing the necessary documents to help shape that prospectus document. So the in-house lawyers, as Dr. Sugum had repeatedly tried to share as well, at least from what we've seen, are core because they would be able to understand the company's incorporation related issues that would hinder it from either going public or actually listing on the exchange. And I'll point some examples. It could be, there is a clause on the public offer which states transferability when or free transfer, because it relates to the free float question as well, freely transferable securities. And some of the memorandum of association or memorandum of article that of a publicly held company as it is currently have some restrictions, whether it's the amount, whether it's the need for in terms of, how much can you actually transfer. In the capital markets, as an investor, if I want to go to the secondary market and transfer one security to security, it shouldn't be restrictive. But some of these issuers have in their memorandum of association restrictive comments that would prohibit, you can't transfer minimum 50 or some, just an example. So these are the issues that only the lawyer who has drafted, the in-house lawyer who have actually been with the company would be able to understand. And this kind of restrictions would not be, you would be having challenges. The in-house lawyer would be the one taking it to the General Assembly for approval, amendment, together with the external lawyer. But not only that, I mean, there are specific cases related to the company. It could be banking sector, it could be insurance sector, that the lawyers would be handling court cases that would impact the risk level of the company. So that needs to be highlighted on the document, on the prospectus, and it would be the lawyer who would be guiding, the in-house lawyer who would be evaluating, who's handling the cases as in be for the document to be shipped. But I'll pause here. Moving out of that, even post registration and post listing, right? There are still going to be informations that the exchange as well as the authority would be requiring, right, on an ongoing basis that would be related to the company. And it's usually the company secretary or the general counsel who would be leading some of these conversations, which are all in-house lawyers. If you have to say, I'm not a technical person in terms of how these are structured, but if you have, that's what you would be calling, Dr. Suyum would correct me here. These are the people you would be calling in-house lawyers. So the legal counsel, the company secretary, most of the time, even they could have a legal department as need be. So it's always about that need for the core function of the lawyers as they've been doing it that would be needed and would be even highlighted in the capital markets. Coming back to the free float and free, I don't know if Dr. Siyumi wanted to say something. I'm moving fast so that in the interest of time.
Yeah, I don't have really much to add. I think you
Okay.
highlighted the points really very well.
Noted. So in terms of the free float, coming to the public offer directive, there is a clause which talks about free transferability of securities, and obviously that's translated to us, we call it free float or freely transferable. Now what we're looking at three core things, right? For us it's about liquidity, maintaining market liquidity, and as part of that we would want the free float or the securities that are listed and are available for trade would not have restrictions. So let's say if you take an example of a publicly held company and the securities are held by employees, right? They usually don't sell them easily. They're not liquid as we would assume as an investor. If I'm not attached to the company, I can actually buy them and sell them easily, right? So if they're what we're calling as a free float is outside the scope, which is shares held by employees, government, it could be held by government, it would be held by directors or promoters. These are not easy to transfer and they're not very liquid in the market, so we don't consider them as a free float. So that's what we're saying when we're talking about a free float requirement on the exchange. But the fundamental notion is for us to be able to have a price discovery, for us to have a liquid market. Don't forget in secondary markets, as Richard already mentioned, that's what we're looking at, liquidity, creating liquidity and being able to price discover. That notion Okay, that notion, and giving access to investors to participate in the market as well, that notion could only be adhered if the securities that are listed on the market are able to easily trade. That would happen if they're not held by these specific groups. So I've mentioned some of them, like the directors, the promoters. It could be government. For example, if you look at Ethio Telco, the 10% is floated, but you remove the 90% still held by government. That's not really floated. You cannot trade that. We don't consider it as free float. So those are the examples I could give now, Deborah, for what we mean by a free float requirement in the exchange. But the underlying principle is to create liquidity and to have a price discovery. We would want to have an easy trade. I'll pause here.
Yorit. Maybe I think due to our restriction in time, this could be our last question. The question is, global consulting firms are significantly shifting towards using AI tools in their work. Similarly in the legal profession as well. So I think the question is, how do you see the way forward, and maybe also even current trends in terms of using AI tools by legal practitioners in doing work, such as drafting any of the legal documents, including prospectus, for legal advisory service in relation to capital market legal services.
Is that a question for me?
Yes.
Okay, that's fine. Wasn't clear. That's fine. I think part of the answer is in the question is AI tools. So a tool is always something that's helpful to have and helps you get a job done, but it doesn't necessarily do the job completely. And that is where I think we're finding AI has very, very useful attributes, things that it can bring to help. So in the context of doing an IPO, you could get a lot of the due diligence and review of the company's background and history reviewed by an AI tool and then checked by the lawyer to be sure that it is actually accurate. I struggle to see how AI is going to draft a prospectus for you because a prospectus is very much a one-off document. I think there are certain parts of a prospectus, like a skeleton or a template, that AI would be able to give us to help us start the process. But you then have to, as individuals, whether as advisors and so on, will have to then build on what is given to you by AI. So, overall, I think it's very helpful. I think it will have the benefit, to go back to the question earlier on around cost. It should, once you have an up and running good practice in the market in Addis Ababa, I think it should help you to speed up and reduce the cost of some of the work that goes into preparing the prospectus and getting the IPO done. As we know, AI will also, technology is already very sophisticated when it comes to price discovery, when it comes to trading information and the interaction between buyer and seller in the stock market. So a huge impact, but I don't think it at the end of the day, it's not going to be able to take away the decision about whether to list. It's not going to be able to take away the decision about who's going to take responsibility for preparing all of this, who are the directors of the company going to be, and as I said, what the prospectus is going to say, because I think a lot of that is really down to us humans to actually have the intuition to provide the right arguments and make a company look appealing and attractive to investors. And maybe AI will do that in long term in the future, but I think for the foreseeable future, by which I mean the next several years, I think we still have a very important role to play, I'm happy to say.
If I may add a point, just a brief point, AI may help really in reviewing huge documents. The time that it takes will be much less with the assistance of AI tools. But there are things which are involved in assessing, weighing. Uh, for example, let's say in assessing whether a case will be decided this way or that way, we have to actually take a human judgment. How do the Ethiopian courts think around these issues? What is the capacity of the Ethiopian institutions, especially judges and courts? What is the precedent like? And I think whenever an issue involves human judgment and cultural things and the psychology of the courts, even other impacts, factors like corruption, etc. I think human judgment is essentially important, and AI would not really replace lawyers and other professionals in that regard completely. Will assist, but not replace, I think.
Thank you, Siyun. So I think before we close it off, in the interest of time, just a few points, questions that were raised and we didn't touch upon. I will briefly highlight them and I will invite the speakers to address the ones that you feel compelled to in your closing remarks. So one of the questions is the role of, the overlap of roles between transaction advisors and legal advisors, and if there is any clear, distinction, or how do we go about finding that clear distinction between the roles. There's also another question about, maybe this is specifically to Richard, what are legislative or practical measures that the Ethiopian capital market should consider not to face a similar stagnation as that of the Kenyan capital market or trading on the stock exchange. I think overall these were the issues that were raised, and we didn't have time to directly address them. But yeah, I can start with Richard and Yodit, and Siyun, you can give us your closing remarks.
Okay, thank you. Yes, very briefly, transaction advisors, lawyers, we don't get into a fight, but there's definitely an overlap at times. I see transaction advisors, financial advisors, as being very critical in finding a market for the shares, potential investors, helping with valuation and determining what the worth of the company is, what kind of securities it should issue, and so on and so forth. And then the overlap with us lawyers, where we're also helping not so much with the pricing and finding investors, but more with making sure that the documentation that is being used for the issue is correct and compliant and is good, high quality. So we should work together, and but there are quite distinct roles in many ways. And then just on the last question is, what can the Ethiopian market do to avoid some of the pitfalls that have happened? Interestingly, I mean, I'm very impressed by the infrastructure that is there in Ethiopia, the laws, the stock exchange, the ECMA. I mean, I haven't read all the rules and regs. I think the most important thing probably is to make sure that the market remains transparent, and that companies that come to market are kept, their compliance levels are as high, their disclosure obligations, so that there is an honest market and investors have confidence that there's proper oversight over the companies that are listed, so that if things are going wrong with a particular company, the regulator can step in. The worst thing that can happen with any market is that investors lose confidence, and confidence is that it's hard won, but very, very easily lost. And I think it's the responsibility of market participants, not just the regulators, but the listed companies, the intermediaries, the stockbrokers, and so on, to try to maintain the highest levels of integrity and transparency. And that will inspire market confidence, which will be really important. And that's something that we've suffered at times from, as I said earlier on when I was talking, we've suffered at times from here in Kenya. So I really look forward to following, what I think will be the huge success that you're going to see in Ethiopia in the future. Thank you.
Thank you, Richard. Yodit, would you like to go next?
Sure, Deborah. I think I would say two things and then close it. Also, it would answer the two questions that I think would have been highlighted for me as well. There is a question around different regulators' cost of compliance issues, and one of the question by Andualam relates to the capital markets as a regulatory body has two regulators. No, it doesn't. It has one regulator, that's the Ethiopia Capital Market Authority, but there is a role for the National Bank of Ethiopia as a primary regulator for the financial sector. Based on the mandate that they have different roles, they have different responsibilities, but I think obviously there are also overlaps in terms of the entities that they would be regulating. But it's like I always say, it's like people, when I was in my accounting life, people used to say, it's very difficult. The accounting regulator asks us to do it this way, but the tax regulator asks us to prepare the financial statements in this way. And my answer is, yeah, they have different mandates. And they would ask you different information, different requests. You can never ask two regulators to have the same, but as much as possible to overlay those requests and try to reduce the cost of compliance. But they have different mandates, so they would be asking different things. So the same applies here as well. The National Bank of Ethiopia regulates the financial sector. The financial sectors not mainly, all of them are publicly held company when they were set up. So they would be regulated in the secondary market as well as the registration by the Ethiopian Capital Market Authority. But obviously the National Bank's interbank money market, and I do need to mention, the money market. So when Richard mentioned about different markets and learnings, we took a lot of learning from different markets, including our neighbors in Kenya, but also from Ghana. So we have the interbank money market, the 1 day and 7 day that's actually trading on the exchange. So it's not only securities, but also cash actually trades on this exchange, which is quite unique. And Richard would agree it's very different model than other markets. So that part, obviously, it's NBE, it's National Bank of Ethiopia, because it's money, it's cash. So I just want to air that out. The second question, but also my closing remark is, people have asked different things about the capital market. Our doors are always open. Our office is actually located at in front of the Awash Bank, the Nile building, 17th and 18th floor. Make an appointment, call us, because I've seen an attendee, Robel by name, who asked, we want to do this as lawyers, we want to come and participate as service providers. Our doors are always open. The more you engage with us, the more we learn and shape the market in a way that would fit all of us. So please, both us, the exchange, as well as the Ethiopian Capital Markets Authority. I'm not speaking on their behalf, but obviously the Ethiopian Capital Markets Authority, their offices at Flamingo Menaye building, they're also available. So you can actually reach out to us by call, by email. We'll make sure to post our email here. Any questions, we're more than happy. And thank you for the platform, Deborah, Aman team, and Richard as well, Bowman team, to share what we have learned so far. Thanks, Deborah.
Thank you, Yodit. Over to you, Dr. Zia.
Thank you. I think Richard and Yodit have covered most of the issues that should be covered in a closing remark. All I can say is that compliance with capital markets laws must be really taken seriously if Ethiopia is really to benefit from what these laws are meant to achieve. If investor protection is to be ensured, if transparency in the market is to be ensured, if corporate social responsibilities to be discharged. So I think we need to take capital markets laws seriously, in that we should think of them. I fear that there is a risk that people may think that all they have to do is check off certain boxes and submit documents that are perfunctorily prepared by people. If we do this, nobody will benefit. So I think we should take this law seriously if Ethiopia is to benefit, if the business community is to, in the end, benefit from these laws and the whole exercise.
Thank you, Dr. Siyu, and everybody who has attended the session. Thank you for sharing your questions and your thoughts with us here. I would also thank again all our speakers for taking the time truly today to share your experiences. We hope to see you on another conversation soon, and we wish you all a great week. Bye.
Thanks,
Thank-
Deborah. Thanks,
Thank
everyone.
you.
Thank you.
Cheers.